I wish you could hear me. So we will now proceed still on the last few topics on motion to quash under Rule 117. Okay. Of course, we have already mentioned this one last time, but we have to discuss it all over again. Okay. We mentioned last time on the political offense doctrine. All right, the political offense doctrine. And what is this political offense doctrine? It is known to everyone that if one is charged for rebellion, all the other common crimes are considered as ingredient of the crime of rebellion. So, the crime of homicide or murder, for instance, cannot be charged separately because it is supposed to be an ingredient of the crime of rebellion, but a component of the crime of rebellion. So now when an accused invokes the defense of the political offense doctrine, well, the rule according to the Supreme Court is that uh, the accused, the burden of proof lies with the accused to prove that the common crimes of homicide or murder and other related crimes are deemed ingredients of the crime of rebellion, so that he can only be charged and be convicted for one crime of rebellion. Okay, that is under the doctrine under the political offense political offense doctrine. So under this doctrine, the common crimes perpetrated in furtherance of the crime of rebellion are divested of its divested the common crimes are divested of their character of common offenses and shall be included as an ingredient of the crime of rebellion. So there are several crimes of homicide, murder, and yet all of those crimes can be considered as an ingredient of the crime of murder. So the only crime which they could be held liable is the crime of rebellion. So the common crimes cannot be punished separately from the political offense. It cannot also be complexed with other crimes or with the crime of rebellion because the crime is simply rebellion. It cannot be said that the crime is rebellion with homicide, rebellion with murder. The crime is simply rebellion, simple rebellion. So the crime is rebellion. So under the political offense doctrine, common crimes committed in furtherance of the political offense like of rebellion are divested of their common offenses. So they cannot be charged separately. So the killing is not considered as homicide. The crime is only one crime, which is rebellion. The killing assumes the political complexion of rebellion as its mere ingredients. Of course, what we are talking is criminal law. But how about under the rules on criminal procedure? What is the rule? Right? Well, according to the Supreme Court, the fact that the crime is alleged to be uh, under the doctrine on political complexion crime of rebellion, yet according to the Supreme Court, the prosecutors are not bound. The prosecutors are not obliged to, to consistently charge them for rebellion. No. In other words, not because in the crime of rebellion there were crimes of homicide or murder, does not mean that the prosecutor is bound to charge them for only one crime of rebellion. The Supreme Court said no. The political offense doctrine does not mean that the public prosecutors are obliged to consistently charge them for the offense of simple rebellion instead of the common crimes. The prosecutor may charge the violators for the crime of rebellion. They can also be charged for homicide. They can also be charged for murder and other crimes. So if there were 5 crimes committed, they can be charged by the prosecutor for the crime of rebellion, for the crime of homicide, for the crime of murder, and other common crimes. Okay, under criminal law, there is only one crime. But under criminal procedure, the Supreme Court said that the prosecutor is not bound to file only one charge against them, charge for rebellion. The prosecutors may charge them for rebellion, homicide, murder, etc. Okay, so the prosecutor may do so. All right. Now suppose you are the counsel for the accused. All right, you are the counsel for the accused, and your view is that your client or clients should be charged for only one crime of rebellion. So it was error on the part of the prosecutor to charge your client, the accused, for several crimes. So that is your view. Of course, that should be your view so that there is only one crime for which your client may be indicted and subsequently uh, be convicted. Okay. Now, if you are the client, if you are the counsel, and that is your view, well, according to the Supreme Court, prove, prove in court that the crime of homicide for which your client is charged, prove that the crime of murder and other crime for which your client was or were charged is but an ingredient of the crime of rebellion, and thus he should be charged for only one crime of rebellion. The burden of proof lies with you to prove that the crime of homicide is but an ingredient in the crime of rebellion. What matters is that the prosecutor is not bound to charge your client for only one crime. They can charge as many crimes as the prosecutor believes have been committed by the respondents, now the accused. Now, what is your remedy? What is your remedy? Well, you have to prove it to the court that the crime was only one crime and that your client should be charged for only one crime of murder. So you have to file the appropriate motion for the dismissal of the crime for homicide, the crime for murder, and other crimes, and the same shall be incorporated as part of the crime of rebellion. That is your burden as counsel for the accused. Now, suppose that it was proven that indeed the crime of homicide, murder, etc. were but ingredients of the crime of rebellion. What shall be done? Okay, so it was proven by the accused that the crime of homicide was committed in furtherance of rebellion. Well, the remedy under that circumstance of the prosecution is that the information may be amended. The information may be amended with the leave of court. The prosecution will file a motion for leave of court with the court for the purpose of amending uh, the information. Okay. Okay. So with leave of court, it should be amended. The amended will not. The information shall be amended. For what? Only one crime of homicide. All the other crimes, all the other information for homicide, murder should be dismissed. What shall be maintained only is the crime of simple rebellion. All the other charges shall be dismissed. But take note that the burden of proof, I repeat, lies with whom? With the accused. Okay? The accused will prove that the crime of murder, etc., are but ingredients of the crime of rebellion. Now, we will move to provisional remedies. Of course, we have discussed this one, provisional remedies, last time. Okay? Well, the rules of court said that a criminal action or a criminal case shall not be provisionally dismissed. A criminal action or criminal case or criminal information shall not be provisionally dismissed except with the express consent of the accused and of course with notice to the offended party, right? And we also discussed last time that once a criminal action is provisionally dismissed, for instance, the crime of attempted homicide, wherein the penalty is only prison correctional of not more than 6 years imprisonment. Once the once the criminal action was dismissed provisionally, it can be revived within a period of 1 year from the time of its dismissal. From the time the prosecutor receives the order dismissing the case, or the private prosecutor, if there is a private prosecutor, or in the crimes of homicide, which is punishable by more than 6 years, or actually reclusion temporal of 12 years and 1 day to 20 years, then should the criminal action be dismissed provisionally with the express consent of the accused and of course with notice to whom? To the private offended party, then the provisional dismissal is good until how many years? Until 2 years. The same can be revived within a period of 2 years from the date of receipt of the order of dismissal. Receipt by whom? By the public prosecutor, or if there is a private prosecutor, the private prosecutor. After the lapse of the period of 1 year in cases filed before the municipal trial court or metropolitan trial court, where the imposable penalty does not exceed 6 years, or in crimes filed before the regional trial court, where the imposable penalty is more than 6 years imprisonment, then the provisional dismissal of the criminal action shall become final after the lapse of 1 year or after the lapse of 2 years, as the case may be. Okay? So, as the case may be. All right. Oh, take note of that. 1 year or 2 years as the case may be. So, the provisional dismissal of the criminal action shall become permanent after the lapse of 1 year or 2 years, so long as the prosecutor has already been served of the order of dismissal. Okay, so 1 year or 2 years as the case may be. Okay, here is the Supreme Court ruling. Kaya inulit ko because we were not able to discuss this Supreme Court ruling, a very important one. Okay, here is a case punishable for not more than 6 years imprisonment. Okay. The case was the criminal action was dismissed provisionally with the express consent of the accused with notice to whom? To the private offended party. So take note that the crime is punishable by not more than 6 years imprisonment. So according to the rules of court, the provisional dismissal can be uh, installed, or it can be reinstated, or it can be refiled, or it can be revived within a period of how many years? Within a period of 1 year from the time the prosecutor received the order of dismissal, or if the private offended party is represented by a private prosecutor within the 1 year period from receipt of the notice or the order of dismissal. Okay. So maliwanag 'yon, maliwanag. All right. In this case, a motion to revive was filed by the public prosecutor within a period of 1 year. So is it correct? Is it proper for the prosecutor to file a motion to revive the criminal action within that period of 1 year? So based on our discussion, your answer will be yes. A resounding yes based on our discussion. Okay, so within a period of 1 year. Okay, so within a period of 1 year. So it was good. It was correct for the prosecutor to file a motion to revive. But somehow, for some other reasons, the motion of the prosecutor was granted. Granted. But the court order granting the motion to revive was issued only after the lapse of 1 year. I repeat, the prosecutor was able to file a motion to revive the criminal action within a period of 1 year. So on time, right? But the issue now is how about the order of the court? The court order granting the motion to revive. We issued after the lapse of 1 year. Okay. So the issue reached the Supreme Court. So is it correct? Is it proper for the judge to issue an order for its revival even after the lapse of 1 year, where the public prosecutor was able to file a motion to revive within a period of 1 year? The motion to revive was filed within 1 year. The court order granting the motion to revive was issued only after 1 year. So is it proper? Siyempre, nakagulo-gulo. Siyempre, if you're the counsel for the accused, your version is that the motion to revive should be filed within a period of 1 year, and the court order granting the motion should be issued within the period of 1 year. Dapat 1 year lahat. That was the version of the accused. Now, if you are asked in the bar examination, what would be your answer? Is the court correct? Is the order reviving the criminal action correct? Yun, maaaring itanong sa bar examination na malilito ka. If you are not aware of this jurisprudence, surely malilito ka. Pero maaaring tumama ka. Siyempre, may instinct naman eh. Maaaring tumama, maaaring mali din. But if you are well aware of the decision of the Supreme Court on this matter, then surely your answer will be correct. What matters then is how you will present it. How will you convince the examiner that you deserve to become a lawyer? Kasi minsan yun nga, tama ang sagot mo, but is it convincing? Were you able to convince the examiner that you will be admitted as a member of the Philippine Bar. Yun ang problema mo. Now, what is the answer here? What is the answer? According to the Supreme Court, it was proper. The criminal action was properly revived by the court. According to the Supreme Court, what matters most in these provisions of the rules of court is that the motion to revive the criminal action which was provisionally dismissed was filed within a period of 1 year in cases of crimes committed, in cases of crimes wherein the imposable penalty does not exceed how many years? 6 years. Or in crimes where the imposable penalty does not exceed is more than 6 years imprisonment. It is important that the motion to revive filed by the public prosecutor should have been made within a period of 2 years. Okay, lumagpas nga. The motion was filed on time, but the court order was issued after 1 year. The Supreme Court said that is proper. That is proper. According to the Supreme Court, to rule otherwise would definitely put the offended party at the mercy of the trial court, which would wittingly or unwittingly not comply with the period. Halimbawa, isinadya na lang na judge. Halimbawa, kumakampi si judge sa akusado. Although the motion was filed within a period of 1 year or 2 years, anong gagawin ni judge? Huli niya, ang order niya, ilabas niya ang order after the period of 1 year or 2 years. Sabi ng Supreme Court, notwithstanding that the order was issued by the court after 1 year or 2 years, as the case may be, so long as the motion to revive the criminal action was filed within the 1 year or 2 years period, then it does not matter if the court issued the order after 1 year or 2 years. Still, the revival of the criminal action is appropriate. It is valid. So, lusot ito. Kaya maganda yan pag lumabas kung sakali it will be asked, masasagot ninyo sa bar examination. Ngayon, yung mga law students, at malay mo is tanong ng professor ninyo sa midterm or final exam. Hindi natin din alam. Pwedeng itanong din niya yan. Pero siyempre, number one paghandaan natin, the bar exam. Kaya lang, kayong mga law students, hindi naman kayo makarating sa bar exam if you will not able to handle your subjects in the College of Law. Kaya ipasa nyo rin. Alright. Now, suppose that the accused failed to file a motion to quash before arraignment. Or while he filed a motion to quash, but he failed to allege some other grounds for a motion to quash, what would be the consequence? Meaning to say, what is the consequence of failure to move to quash the information before arraignment? Well, the failure of the accused to move for the quashal of the information before arraignment, that would constitute a waiver. It is deemed a waiver of the ground for a motion to quash. You did not file a motion to quash? Yes, Your Honor. You forgot to state this ground as a motion to quash. You, as general rule, your right to question such matter is now deemed waived. That is a mere general rule. There are exceptions. Okay? So, there are exceptions. In other words, there are grounds that can still be invoked by the accused, even after arraignment, even during trial. Still, the accused can file a motion to quash, and it will be considered by the court. For instance, the accused was already arraigned. There was already a trial. But the information do not charge an offense. The information do not charge an offense. During the trial, it was discovered the defense counsel, the information do not charge an offense. Okay, you're the counsel, you're the defense counsel. You are asked by the examiner, are you going to file a motion to quash? Siyempre, for the accused ka, kailangan panalo mo. The answer is yes. You have to file a motion to quash. But your client was already arraigned. So the prosecutor will now object. Sabi, oh, we object, Your Honor. It is too late now for the accused to move for the quasal of the information. Oh, why? Why, Mr. Prosecutor, Madam Prosecutor? He was already arraigned. Okay. Ask the examiner. You are the judge. Rule or resolve. Yun ang tanong ng examiner. Resolve. With reasons. So, yun ang mga kadalasang tanong. Resolve with reasons. How do you answer that kind of question in the bar examination? Huwag niyong sabihin, maraming mga estudyante nadidismaya ang mga faculty. Yun yung tanong, resolve with reasons. So sabihin agad, the contention of the prosecutor is not tenable. O kaya, the contention of the accused is not tenable. Mali ba ang sagot? Hindi naman. Kung tama ang reason niya, tama naman. But the way the answer is made, it is not convincing. Your answer is correct, but the examiner may not be convinced that you deserve to become a lawyer. Remember, pag sinabing resolve with reasons, ibig sabihin, you are the judge. You do it as if you are the judge. Yun ang ibig sabihin doon. Anong sabihin mo? Well, the motion to quash is granted. Okay? The motion to quash is granted. While it is true that if one of the grounds for a motion to quash was not invoked by the accused before arraignment, such ground is deemed to have been waived. Okay? But in this case, since the ground invoked is that the facts do not charge an offense, the information do not charge an offense, that kind of ground can still be maintained even after the accused has already been arraigned. It cannot be waived. Right? So, the objection of the prosecutor is actually cannot be given credence. Right? Kung sakaling tatanong sa bar exam, simpleng tanong yan na totally hindi naman mahirap, but if you are not well acquainted with the provisions of the rules of court on this, surely you will find it difficult to answer. Yan ang hirap sa bar exam. Dami mong binabasa, yung tinanong, hindi mo masyadong kabisado, malilito ka. Mabuti kung ang tanong, define. Ayan, yung mga magagaling mag-memorize yan, kayang-kaya nyo yan. Enumerate. Paano naman yung hindi mahusay mag-memorya? Kawawa naman. Pero pag itong klase mga problem, hindi pinag-usapan ang memory work dito. How you understand the provisions of the law, the jurisprudence, and how will you apply it in the given question. Okay, another one. Suppose that your client, the accused, was charged for prostrated homicide. That information was filed by the office of the prosecutor where? With the municipal trial court or metropolitan trial court. Arraigned, your client pleaded not guilty. Trial proceed. So there was trial. Now, during the course of the trial, you as a counsel realize that, my goodness, prostrated homicide. The penalty for prostrated homicide is prison mayor of 6 years and 1 day to 12 years. So jurisdiction is with the regional trial court. I have to move for the quasal of the information. On what ground? That the court trying the case has no jurisdiction over the subject matter. Are you going to do that? Yes, you have to do that. File a motion to quash on the ground that the court do not have jurisdiction over the subject matter. Mr. Prosecutor, are you going to object? Yan ang tanong. If you are the prosecutor, all right, pwedeng tanongin ng examiner yan. Tandaan nyo, if you are the prosecutor, are you going to object? Yan ang tanong. Although napakasimpleng tanong. Are you going to object? Siyempre mag-isip ka. You're a public prosecutor. You have to fight it out to convict the accused. Are you going to oppose or to object? No. In actual practice, anong sasabihin ng prosecutor? Hindi nakita niya, hindi niya nakita. Matuwa ka pa nga na nag-file. Anong sabihin mo? Well, in that case, Your Honor, we join the manifestation. We join the motion of the accused for the dismissal of the criminal action. Wala namang problema kasi without prejudice to its refiling because the court do not have jurisdiction over the subject matter. Thus, if an information will be subsequently filed with the regional trial court, the court of competent jurisdiction, your client, the accused, cannot validly invoke double jeopardy because there is no way that he can be convicted before the metropolitan trial court or municipal trial court because those courts do not have jurisdiction over the subject matter. In short, that kind of ground, the ground that the court do not have jurisdiction over the subject matter cannot be waived. It will never be waived despite the fact that the accused was allowed to be arraigned. He entered the plea of not guilty and he even participated in the trial. Okay, so losot if asked in the bar examination. Another ground for a motion to quash or a motion to dismiss that cannot be waived is that if the criminal action has already been extinguished or the liability has already been extinguished by prescription, even if the accused, your client, has already been arraigned and on trial, still that ground can be invoked as a ground for a motion to quash. It cannot be waived. Another ground for a motion to quash that cannot be waived. In other words, that a ground that can be invoked even after arraignment during trial is that double jeopardy. The accused has been previously acquitted or has been previously convicted of the same offense charged. So, he can invoke double jeopardy even if he was already arraigned. It cannot be waived. That is a constitutional right that cannot be waived. The state already lost its authority to once again penalize the accused, the offender, because he was previously acquitted or the case against him, in the criminal case against him, he was convicted. Wala na, convicted na. He cannot be charged for the second time. Or acquitted, he cannot be charged for the second time. And that is why still he can invoke that ground for a motion to quash. Well, another one is that if the criminal action was dismissed or otherwise terminated without the express consent of the accused. And subsequently, he was charged in court for the second time. Then he allowed himself to be arraigned. He participated in the trial. Question: during the trial, may he invoke as a ground for a motion to quash that he was previously charged of this case, and that case was dismissed without my consent, or it was terminated without my consent. Kasi winidraw ng prosecutor. Unless the information was withdrawn. The prosecutor files a motion to withdraw the information before the accused was arraigned. Wala yan. So the criminal action was dismissed without the express consent of the accused, but he was not yet arraigned. So if ever the criminal action will again be filed, he cannot invoke that as a ground for a motion to quash. Okay, suppose that your client was arrested by virtue of a warrant of arrest. Okay, so there was a warrant of arrest. Okay, merong warrant of arrest. Okay, but the issuance of the warrant of arrest was procedurally defective. Okay. Warrant. There was a defect of the issuance of a warrant of arrest. Why? Why there was a defect? The court issued a warrant of arrest without examining the documents coming from the office of the prosecutor. We are referring to the affidavits and counter affidavits. What was examined by the court is only the information in the resolution of the prosecutor. So defective ba? Yes, defective. According to the Supreme Court, that is defective. Okay? The information is defective. Now, if you are the counsel for the accused, what would be your remedy? Your remedy is to file a motion to quash. Which one? The information? Motion to quash the warrant of arrest. Bakit kaya hindi nabasa ni judge yung complaint affidavit, counter affidavit? Kasi hindi na iatas ng prosecutor. Ang nandun sa kanya, information lang sa resolution, nag-issue na agad ng warrant. Well, according to the rules of court and Supreme Court jurisprudence, the court should examine the affidavits, the record of the case, not just the resolution. Because, as we learned in our Rule 112, yung hindi pa nakarinig, although kung may sunod, maulit pa naman ito next year, criminal procedure. Alright, anong nakalagay? According to the Constitution, insofar as the issuance of a search warrant is concerned and the warrant of arrest, the court should personally examine the complainant and the witnesses he may produce. But according to the Supreme Court, in so many cases, that insofar as the search warrant is concerned, that rule of the Constitution shall be strictly applied. But insofar as the warrant of arrest, it is not mandatory, it is not necessary that the court will examine the private offended party. It is not necessary that the court will personally examine the witnesses. It is enough. It would suffice if the prosecutor will examine not only the resolution but the documents attached. And we are referring to what? The affidavits of the complainant and the witnesses. Well, according to the Supreme Court, under those circumstances, the public prosecutor shall be considered as the commissioner of the court for the purpose of conducting personally the examination of the witness. So that is enough. In our example, walang nabasa. Walang nabasa si judge na complaint affidavit and counter affidavit. And yet, he issued a warrant of arrest. So your remedy is file a motion to quash the warrant of arrest. Why? Because of the defect. And because of that defect, the court did not acquire jurisdiction over the person of the accused. That is your ground. But suppose, nakalimutan mo yung jurisprudence or the doctrine we have earlier discussed at natanong sa bar examination na saklap. Hindi ko kayo sinisiraan ng loob. Big sabihin, strive hard. Hindi pa pwedeng pahapyaw-hapyaw lang. Nako, sabi, memorya mo minsan yung kodal. Hindi pa pala lusot. wala pala. Dig deeper. Alright, anong sasabihin mo? Okay. You allowed your client to be arraigned. Sige, okay na. Plead guilty, not guilty. Wala yan. Nananalo tayo yan. Not guilty. Kung bahala dyan. Not guilty or no? Not guilty. Okay. Pre-trial. Because under the revised guidelines on continuous trial, arraignment, pre-trial, agad-agad yan. Hindi. Yun mismo, sabay-sabay yan. Arraignment and pre-trial. Comes now the trial. Okay. You discovered that there was a defect in the issuance of the warrant of arrest. Question, can you still invoke that ground? Motion to quash the warrant of arrest and the subsequent dismissal of the criminal action on the ground that the court did not acquire jurisdiction over the person of the defendant or accused. Bad for you. Bad for you because you allowed your client to be arraigned. The remedy is do not allow your client to be arraigned. File the necessary motion to quash before arraignment. Pumayag ka, nag-pre-trial ka pa, nag-trial pa. Under that circumstance, the motion to quash the warrant of arrest or even to quash the information on the ground that the court did not acquire jurisdiction over the person of the accused has already been waived. By the act of the accused in entering a plea of guilty or not guilty, he already submitted his person to the jurisdiction of the court. Kawawa itong kliyente mo. Kung sa bar itinanong at hindi mo alam yan, kawawa ka. Kawawa. Kung ganyan ang mga tanong kahirap, kung ganyan kahaba, baka 3% ang ibibigay ng examiner dyan. 3%. Tapos yan ang hirap sa bar 3%, may kadugtong yun. 2%. I'm not discouraging you about the bar. Hindi naman. I'm just saying, be prepared. Paghandaan talaga ng maigi yan. Hindi yung basta-basta Yung iba kasi minsan sasabihin nyo, iba't yung pinsan ko, lasinggero, pumasa. Si ganito, lagi lang pasyal-pasyal, pumasa. Kasi yun yung nakita mo. Pasyal-pasyal, hindi mo lang alam pag nasa bahay, grabe pala mag-aaral. Sabi, yun lang ang niya niloloko lang kayo nila na kunyari, wala. Marami kasing taong ganyan Natingnan mo, paisi-isi, kala mo, hindi nag-aaral yun. Kahit ako, when I took the bar, attend ako yun sa FEO, di naman ako nagdadala talaga ng mga librong malalaki. Dala ko yung maliit lang na kodal. Yun lang talaga Pero yung iba, ang daming dala. Ang daming libro. May mga papel pa. Kung ano ng mga papel, dinadala. Mga jurisprudence daw. Sa gabal yun While in the review center, dapat nakakonsentrate ka sa reviewer. Siyempre may contain, magdala ka din ng papel sa ballpen. Pagka hindi mo kasi alam, inote mo, hindi mo alam. Ibig sabihin, pag uwi mo, pag-aralan mo. Yan ang ibig sabihin. But kodal? Sa kodal kasi, pag nasa review center ka, in the review ba, sa bar review, kodal ang dala mo, makakabasa ka dyan hanggang 5, 10, 20, or even 50 kodal provisions. Makakabasa ka. Ang laking bagay nun. Ang laki. Pero kung textbook ang dalhin mo, hindi mo mababasa yun. Hindi mo mababasa. So, yun yung technique. Isa sa mga bagay, kanya-kanya. That is one of the techniques. All right. Now, how do we distinguish dismissal of a criminal action from an acquittal? Kapareho ba yun? Dismissal and acquittal. Okay. Except on dismissal on demurrer to evidence filed by the accused or for violation of the right of the accused, the constitutional right of the accused to speedy trial, the dismissal of the criminal action will not result in his acquittal. So dismissal is not acquittal. Okay, tandaan nyo dismissal of a criminal action is not acquittal. Tandaan nyo. Dismissal. But are there any circumstances that a dismissal amounts to an acquittal? Meron ba? Yes. Yung tinatawag nating demurrer to evidence. What is this? Demurrer to evidence. Pasensya na doon sa mga law students kasi nag-lockdown na, nag-demurrer, pero i-discuss pa naman uli yan. Kailangan lang natin medyo i-correlate natin para maganda yung discussion. Alright, so, what is this demurrer to evidence in a criminal action? Actually, motion to dismiss yan. Okay, motion to dismiss. Pero, wag mong tawagin motion to dismiss in a criminal action. In this case, in this regard, should be demurrer to evidence. Why? Pag sinabing demurrer to evidence, pasok nyo pag sinabing demurrer to evidence, ibig sabihin, the evidence for the prosecution is not sufficient. And that rule is applicable not only in a criminal action, but also in a civil action. Pareho. All right. Now, the prosecution already presented its evidence. Kung daming testigo, piskal, ilang testigo mo? 10. Sige, present mo 10. Wala na bang ibang kaso dito? Yun sa'yo lang. Alam mo naman dito sa atin, probinsya, walang kaso, ito lang. Mababait ang mga tao. 10 kaso. 10 testigo presented. All right. Now, after the presentation of the 10 witnesses, the prosecution rested its case. Ibig sabihin, tapos na siya. Well, Your Honor, we do not have any witnesses anymore. Oh, what is your pleasure, Mr. Prosecutor? Well, Your Honor, we are resting our case. All right. With the admission of our evidence, Your Honor, we rest our case. All right. Defense. Okay. Defense. Matataranta ka ba? Okay. Now, if you believe, kung ito din ang sa bar exam, if you believe that the evidence for the prosecution is not sufficient to convict your client, that the prosecution failed to achieve the quantum of evidence in a criminal action which is proof beyond reasonable doubt, then what would be your remedy, Mr. Defense Counsel? Your remedy is to file a demurrer to evidence. Yun yung demurrer to evidence. But take note, huwag ka namang padalos-dalos, okay? Can you file a demurrer to evidence without leave of court? Yun yung tanong. Can you? Yes. But can you file a demurrer to evidence with prior leave of court? Yes, and that is the better, right? Mas mabuti nga, magpaalam ka. Pag sinabing leave of court, Your Honor, pwede ba mag-file ako ng demurrer to evidence? All right, granted. Meaning, you filed a demurrer to evidence with prior leave of court. Okay, may paalam. There is permission from the court, meaning there is prior leave of court. Okay, so you already, after the permission from the court, you filed a demurrer to evidence. In other words, there are two pleadings. In this case, dalawang pleading. Anong unang pleading mo? Motion for leave of court to file what? Demurrer to evidence. Yun ang unang mong pleading. Granted. Granted. Anong pangalawang pleading mo? Demurrer to evidence na. Meaning you're attacking the evidence for the prosecution as insufficient. All right. Ang ganda ng sulat mo, demurrer to evidence. Grabe. Ilang kayong lawyer gumawa? 5. Ang daming research. Grabe. Sobrang gandang pagkagawa eh. Pero sabi ni Judge, denied. Patay. Sama ng loob nyo, no? Ilang araw niyong ginawa, walang tulugan. Binayaran kayo ng kliyente, libo-libo. Just for that. Demurrer to evidence. Siyempre, mahalang bayad. Demurrer to evidence. Minsan dyan inaatake yung mga lawyers. Doon yung si Doming, membro ito ng This Is Your Law. Nagpo-post kasi ako about mga payment ng abogado. Binabati ko yung mga abogado dahil sa bayad. Meron pa nga isang nagsabi doon sa isang grupo sa mga law students. Baka membro din kayo. Sinasabi doon, dapat mayroong mga grupo ng lawyer na nag-advocate na ipatanggal ang mga lawyer ng mga sirao. Alam nyo, hindi ganon. Talagang may bayad. Alam nyo yung mga lawyer, kala mo lang, ganun lang. Papel. In how many pages yan? 10 pages ginawa. Tanungin mo, ilang oras niyang ginawa. How many hours did he spend for that? Hindi mo ba yung babayaran? Dahil yung papel 10 pages lang? Kung sabi mo hindi, ikaw ang gumawa. Ako, pag sinabihan ako ng taong ganyan, Jesus, ikaw ang mag-lawyer sa sarili mo. Mag-lawyer ka, sarili mo. Masyadong hinahamak yung mga lawyer pag pera ng pinag-usapan. Ako, siyempre, dati naman ako sa gobyerno, pero pinagtatanggol ko ang mga private lawyer. Ang sinasabi ko, pag ang lawyer ba sumakay ng tricycle, walang bayad? Tandaan nyo yan. Pag bumili bang lawyer ng kalahating kilong bangos, walang bayad? Pagka ang lawyer nagpaggasolina, libre ba? Hindi, di ba? See. May bayad. Mahal. Mahal pala. Huwag mong kunin siya. Ako sa totoo lang, dami kong sinasabihan. Dito sa Antipolo, ako dalawa lang. Walang bayad or mahal ang bayad, mamili ka. Kasi hindi ako papayag, nababayaran mo ako ng barya-barya. No, but kawawa naman ako. Mag-a-appear ako sa court ng baryang bayad mo. Sa'yo na yan. Bayaran mo ako malaki, kaya papipiliin kita. Free or with fee. Mamimili ka na lang. Kung maganda naman ilaban yung kaso, kahit libre, okay lang. Pero huwag mo akong bayaran ng barya, pangit. barya, sa libre na lang. Mas maganda kaysa bayaran ka ng barya. O, mukhang pera ang lawyer. Hindi sa mukhang pera. Ilagay mo sa tama. Ilagay mo sa tama. Kaya, study hard. Be a lawyer. Hindi naman pera ang habol, but money follows. Sumusunod yung pera eh. Sa gawa mo sumusunod. Pero kung mukhang pera ka, singil ka ng singil, hindi ka naman nagtatrabaho, matanggal ka rin pagka-abogado dyan later on. Alright, tanggal ka rin pagka-abogado. Masyado kang maningil. Sobra naman. Reasonable fee. Reasonable fee lang. Okay, so, demurrer to evidence. Your demurrer was denied, right? Kahit super gandang pagkagawa. Alright, ang question is, can you still present defense evidence? Can you? Well, the Supreme Court said, yes. Why is it that you are allowed to present defense evidence? Because you ask prior leave of court before you filed the demurrer to evidence. So, yun yung kabutihan na nagpapaalam sa court. But suppose you did not ask permission from the court. You did not file a motion for leave of court to file demurrer to evidence. You simply filed a demurrer to evidence and it was denied. Question, can you still present evidence for the defense? No more. O kaya you filed a demurrer, you filed a motion for leave of court, it was denied. Despite the denial of your motion by the court, you filed a demurrer to evidence. Your demurrer was denied. Can you present evidence? No more. Kasi tigas ng ulo mo if you are asked by the examiner. So under that circumstance, you are the judge. Can you render a decision? Yes, you can render a decision. What would be the basis of the decision, Your Honor? The basis is that, what would be the basis? The basis would be the evidence presented by the prosecution. That would be the basis. But it does not mean that your client will be held criminally liable. No. Kahit na deny yung demurrer mo, it is possible that still the court will acquit the accused. Maroon pa rin possibility yan. Kasi kung binasa na niya, nako, may kulang dito. Ay nako, i-absuelto yan. Absuelto. Okay, so another one. So what do we mean by that? That is a dismissal, okay? That is a dismissal. Yet the dismissal on account of a demurrer to evidence is an acquittal. Dismissal ang tawag pero acquittal yan. Since it amounts to acquittal, he cannot be charged anymore for the same crime without violating his constitutional right. Against what? Against double jeopardy. Okay. Yun yun. But suppose during the trial, nako, itong mga prosecution witnesses, laging absent. Laging absent. First time na ma-absent, anong gagawin mo? Sabihin mo lang, ready, Your Honor. Third time, wala pa rin. The third time around, anong sasabihin mo? Will you Honor, please, this is the third time that the prosecution witnesses failed to appear despite notice. And we have been ready all those times, Your Honor. So what is your desire, Mr. Counsel, Defense Counsel? Your Honor, please, I move. Mayroong motion dito. May I move for the dismissal of the criminal action. The accused, through this representation, is invoking his right, his constitutional right on speedy trial. Naku, patay ka. Question mark si Piskal dyan. Wala siyang magawa. Si Judge, ngiti na lang. All right. Dismiss, granted. Dismiss, all right. Was it a dismissal? Yes, it was a dismissal. Yet, although it is a dismissal, it is also an acquittal. Why an acquittal? Because according to the Supreme Court, the ground for the dismissal is based on what? Anong pinagbasyan? Based on the constitutional right of the accused to what? Speedy trial. So, its dismissal amounts to an acquittal. Amounts to an acquittal. Babay ka na lang. Oh, Piskal, sorry, wala ka na. Private complainant, wala na. Kasalanan, hindi naman kasalanan ni Piskal. Lagi naman siyang nandyan. Ang wala yung mga witnesses. So, that would amount to an acquittal. Okay. Another distinction between a dismissal and an acquittal is that pag sinabing acquittal, it is always based on the merits. Yung merito ng kaso yan, kaya acquittal. Based on the merits. The defendant or the accused was acquitted because the evidence for the prosecution does not show the guilt of the accused beyond reasonable doubt. So that is acquittal. Dismissal does not decide the case on the merits. It does not say that the accused is not guilty. Yun yung dismissal. Kaya lang, depende sa ground for dismissal, it may amount to an acquittal. Okay. So, tapos na tayo on Rule 117. Of course, we have taken up other rules. Siguro, pag may lumabas doon, lalo na itong kukuha ng bar, pag may lumabas doon, tandaan nyo yan. Reviewin nyo lang ng reviewin, hindi kayo makakamali. Pero do not be too confident. Sabihin na, hindi, naintindihan ko na. Wala yan. Sabihin, naintindihan ko na. Naintindihan mo na, pero ulitin mo. Para hindi talaga naintindihan lang pumasok. Actually, dito, kung nandito yung mga estudyante ko sa PUP, pag nagsalita ako doon, iba eh. Ang sinasabi ko, not just understanding the law, okay? Implant that in your what? Not only in your mind, in your heart, but also in your veins. Ipasok mo lahat yan, so you will pass the bar. Yan ang sabi ko sa mga taga-PUP. Kaya sa PUP, awa ng Diyos naman, one of the top performing law schools in the country. Kasi mga estudyante doon talagang talagang kung kulang na lang gumapang, igagapang talaga nila yan. Mag-aaral ng maigi. Kung hindi ka gagawa ng tudo-tudo, mawawala ka sa PUP. Ang hirap, ito, may mga taga-PUP dito, ang hirap, mag-graduate ka lang ng PUP, matindi ka na. Ito, nandiyan naman yung UP. Marami naman. Ang tinutukoy ka lang yung sa PUP. Mag-graduate ka lang, matindi ka na. Grabing survival. Mahirap. Would you believe ba, PUP, College of Law? Bago lang naman ang law school yan, start 2001. Would you believe, wala pang nag-graduate dyan, walang nag-graduate dyan na cum laude? Kasi nakikita namin sa ibang law school, graduate, mag-summa cum laude, magla-cum laude. Sa PUP, hindi pinapansin yan. Bakit? Ever since, walang nag-cum laude. Kaya yung mga taga-PUP dito na nakarinig, huwag na kayong mangarap. Actually, sinasabi ko sa klase yan, huwag na kayong mangarap cum laude. Importante yan. Basta makapasa lang kayo dito, kahit 3, that is enough. 3 nga, pero malaman. Yung ibang estudyante, ang grade 95, kalahati lang ang laman. Ikaw, 3, 95 yung laman. O, sinong papasa sa bar? Ikaw, yung 3 ang grade. Hindi yung 95 ang grade. Wala yon. Hindi yan lulusot. Ang ibig kong sabihin, kasi nandito pa naman tayo, law students, law graduates, study hard. Yun lang talaga ang paraan. Walang iba. Ang bar exam, hindi naman super hirap yan. It is a matter of good preparation. If you're not well prepared, wala yan. Di, okay na. Summa cum laude din naman ako ng undergrad. Valedictorian ako ng high school. Sus, kalimutan niyo yung mga... Wala yan. Hindi yan kailangan. Ang kailangan is your preparation. Okay, so we are now through with the motion to quash and other relevant rules. So we will now move to pre-trial. Now, pre-trial in a civil action, pre-trial in a civil case is mandatory. So you are now asked, is pre-trial in a criminal action mandatory? Yes. So pareho lang. Civil case, criminal case, mandatory. Now, what are the factors to be considered by pre-trial? Bakit may pre-trial? Lalo na sa mga second year pa sa College of Law. Pre-trial. Sabihin, bago mag-trial, may pre-trial. Anong purpose? Actually, the basic purpose of a pre-trial is to expedite the proceeding. Kaya, and that is why during the pre-trial, the court, the prosecution, and the accused will consider what? Plea bargaining. Plea bargaining. Ano yung plea bargaining? Parang sa tindahan. Di ba? Kalahating kilo na lang. Hindi, 1 kilo talaga. Kalahati na lang kasi wala na kaming pera. Sige. Alright, sige. That is also true in a criminal action. Like for instance, your client was charged for uh, attempted homicide. Pero walang sugat. Meron bang crime attempted homicide walang sugat? Yes, binaril, hindi tinamaan eh. Or sinaksak, hindi tinamaan. Nadaplisan lang. So, attempted homicide because there is intent to kill. Now, can there be plea bargaining? Yes, there can be plea bargaining. That the accused, during arraignment, will enter into a plea of guilty to a lesser offense of less serious physical injuries or even serious physical injuries. Is that allowed? Well, that is allowed. Plea bargaining under that situation is allowed. In fact, in drug-related cases, plea bargaining is allowed. Plea bargaining is allowed. So if one is charged for Section 11, violation of Section 11 of the revised, the Section 11 of Republic Act 9165, the Dangerous Drugs Act of the year 2002, he can plead guilty to a lesser offense. What lesser offense? Section 15 na lang, Your Honor. What is Section 15? Using or sniffing shabu? My goodness. Pero kung ako ang prosecutor and I have good evidence to convict him for sexual 11, di ako papayag. No. Pangit yan. Violation of Section 11, punishable by imprisonment of 12 years and 1 day to 20 years. Pero yung sniffing, the first offense, punishable by what? Punishable by what? Rehabilitation. Mandatory rehabilitation for 6 months in a government drug rehabilitation center. Bagay, when I was a trial prosecutor, never. Hindi ako pumapayag pag mga ganyan. Ay, hindi. Ay, wala akong pakialam. Pulis, umupo ka dyan. Sabi mo, pulis, nakunan mo siya ng 10 gramo. Prove it in court. Tanungin lang kita, prove it. Hindi naman kami ang piskal ang nagsisinungaling. Magtatanong lang kami. Prove mo yan. Yung pala, walang nakuha. O, naku, bahala ka. Ma-acquit pa. Kung na-acquit, so what kung ma-acquit? Hindi naman. Kung kasinungalingan, kasinungalingan. Alright, so, plea bargaining. Okay, plea bargaining. Another one is that stipulation of facts. Okay, stipulation of facts. During the pre-trial, usually tatayo, alright, pre-trial, mandatory yan. Nung araw, kahit mandatory yan, pinapalusutan lang yan. Salita, tatayo yung accused, ayaw makipag-stipulate ayaw makipag-pre-trial. Magsasalita lang yan, Your Honor, please, we move that the pre-trial be terminated. Uso yan, sabi ni Piskal, yes, Your Honor, please, we join the manifestation. Alright, proceed. Hanggang trial na, is-schedule. But later on, hindi na ginagawa yan. Totoong pre-trial talaga. There must be what? Stipulation of facts. Alright, Mr. Prosecutor, alright. Will the accused admit, or can we stipulate that that the accused was arrested in Barangay Inarawan in Antipolo City on such a date? Sasabihin agad ng defense, that is on record, Your Honor. It cannot be the subject of stipulation. May barabarahin ka niyan. Mayroong bara. Kaya dapat yung stipulation of facts, yung totoo, yung hindi naman, yung hindi pa settled. Pero you can offer an stipulation. Will the accused stipulate that on such a particular date and time, he was in Barangay Antipolo, Barangay Inarawan, Antipolo City? We stipulate that. We admit, Your Honor. Yan na. So, since there was stipulation or admission of certain facts, those facts already stipulated or admitted need not be proved anymore in court. Do not prove it because it was already agreed upon. It was already stipulated by the parties. Sayang ang oras ng court. So, no need. So, all matters which has been agreed upon or stipulated, or facts or documents which had already been admitted, do not present evidence to prove its existence anymore. Another one for pre-trial is the marking for identification of the evidence of the parties, evidence for the prosecution and the defense. Usually, ginagawa doon sa branch clerk of court, sila na magmamarka. Paano kung criminal case, si fiscal trial, bahala na kayo doon, mamarkahan. Yun ang totoo in actual practice. Isa lang ang katawan ni fiscal eh. Nagta-trial siya, at the same time, nagmarkahan sa kabila. Yun ang totoo. Isa lang yung fiscal. Dapat dalawang fiscal, isang court. Alright, another one is the waiver of objection to admissibility of evidence. Halimbawa, nakita ng fiscal, naku, unlawful yung warrantless arrest. Kaya, the subsequent search is also unlawful. So, the shabu taken from the accused is what? Fruit of the poisonous tree, and thus inadmissible in evidence in court. Right? O, sasabihin na naman ng prosecution, Your Honor, may we ask the defense that he will be waiving for his objection to the admissibility of the white crystalline substance methamphetamine hydrochloride, also known as shabu, taken from the accused. Oh, sabi ni Piskal, anong sabi ng akusado? hindi yan papayag. We're not waiving, Your Honor, please. We're not. In fact, that is our defense. Walang magawa si Piskal. That is our defense. The evidence is inadmissible. Of course, another one, which is sometimes damaging. All right, during the trial, minsan magagaling yung mga judge. May judge siya na matinik eh. Sasabihin, okay, pre-trial. Sasabihin ni judge sa defense, defense, what is your, counsel, what is your defense? Ako, diyan mahirapan yung counsel, defense. What is your defense? Pero nakarinig na akong lawyer na marunong umiiwas dyan. Well, Your Honor, please, we cannot divulge right now, Your Honor, our defense. Merong umiiwas. Hanggat maaari, yun talaga ang dapat gawin. Pero pag sinabi mo, your defense, self-defense, Your Honor. Good. That is all right. Defense, self-defense. If that would be your defense, which you said in which you informed the court during the pre-trial, anong sabihin ng judge? All right, the order of trial should be modified. All right, order na agad. Order. During the pre-trial, the accused through counsel having manifested that his defense is self-defense, the order of the trial shall be modified in the sense that instead of the prosecution presented its evidence, it should be the defense who will present its evidence. Tapos ka dyan. Tapos ka. Because ano bang ruling sa criminal law? Anong sabi sa criminal law? Including the rules of procedure, evidence. Once the accused invokes any justifying circumstances, even exempting circumstances, like self-defense, the burden of proof to prove that the killing is justified lies now with whom? With the accused. The Supreme Court said, having admitted the act of killing, I'm not saying having admitted the commission of the crime, having admitted the act of killing the victim, he cannot deny that anymore. So he has to prove that the killing is justified. Nako, patay ka dyan. Yun ang mahirap. Although I have encountered that once. Naawa din ako sa akusado. Kawawa. Walang magawa. Nautakan ni judge. Magaling yung judge. Magaling mag-isip eh. Alright, so modification of the order of trial. Also, during the pre-trial, the court will issue such other orders involving matters to promote a fair and expeditious trial of the criminal and civil aspect. In other words, from what we discussed, it is clear that the purpose of the pre-trial is really to expedite proceedings in criminal action, for the early disposition of the criminal action. Yun talaga ang purpose doon. So, now, Suppose that during the pre-trial, the accused did not appear. Despite notice, but hindi siya, hindi on bill naman. Homicide lang naman ang kaso of billable offense. Well, in the conduct of the pre-trial under that situation, the court shall proceed with the pre-trial. The court shall proceed with the pre-trial despite the absence of the accused, provided that he was duly notified. Even in the absence of the private offended party, the pre-trial shall proceed. So there will be, as I repeat, yung sinasabi, there will be proposals for the stipulations of fact during the pre-trial and the identification, the marking of the documentary evidence. All right? Now, after the pre-trial, ito, ingat kayo dito, mayroong Supreme Court ruling dito na maganda. Maganda. After the pre-trial, the court shall immediately issue a pre-trial order. The pre-trial order shall be served upon the parties on the same day, meaning the pre-trial order shall be served upon the public prosecutor, including the defense. The defense. Okay. Now, so there is now a stipulation, all right, of both the parties. Okay. Stipulation. So, stipulations of the parties. The issuance of the pre-trial order. Okay, nandiyan na yung pre-trial order. Okay, mayroong pre-trial. According to the rules of court, the pre-trial order shall be signed by the accused and his counsel. It shall also be approved by the court. But suppose the pre-trial order was not signed. The pre-trial order was not signed by the accused. What is the effect? The effect is that the stipulations, the admissions during the pre-trial shall not be binding against the accused. Not binding, as if there is no agreement at all, because it was not signed by the accused or his counsel. And his counsel, dapat silang dalawang pipirma. Pag hindi pirmado ng counsel, the evidence, the admitted or stipulated facts is not binding against the accused. Also, it requires the approval of the court, but according to the Supreme Court, the approval of the court has no adverse effect insofar as the issue of the admissibility of evidence, because the signature of the judge approving the pre-trial order simply show that the pre-trial is under his direct supervision and control. Yun lang ang ibig sabihin. Kailangan permado. Okay, ito naman yung side question. Suppose that the pre-trial order was not signed by the accused or the counsel or both of them. Wala. You are the public prosecutor. What would be your remedy? Baka dalhin mo, judge, hindi na pirmahan ako. Ihabol dun sa kulungan, pipirmahan. Si attorney dun sa law office, ihabol. Is that your remedy, Mr. Prosecutor? Wala sa rules of procedure yan. There is no Supreme Court ruling even on that. So your remedy as a public prosecutor is that, or private prosecutor. Comes now the trial. Trial now, right? You present your witness. Witness number 1. Okay, upo ka. Salita. Anong gagawin mo? You ask him questions and prove everything, even those already admitted during the pre-trial. Because I repeat, the admissions, the stipulations during the pre-trial is not binding against the accused because the pre-trial order was not signed by the accused or his counsel. Yun ang remedy ng public prosecutor. Pwede bang itanong sa bar yung remedy? Mare, as public prosecutor, what would be your remedy? To present witnesses, to prove the facts already stipulated. Halimbawa naman, nakalagay din sa bar exam, the defense objected. You object, Your Honor, to the line of questioning made by the prosecutor. Why? Oh, why? Because those matters has already been agreed upon, stipulated upon during the pre-trial. Anong sasabihin? Okay, you're the judge. Roll on the motion. Well, objection is sustained or overall. Objection is overall. Overall, prosecutor proceed. Why? Because the pre-trial order was, you did not sign it, Mr. Counsel. Accused, you did not sign it. And under the rules of court, the stipulations, the admissions are not binding against the accused. So it is appropriate for the prosecution to prove all those matters even though already agreed upon or stipulated during the pre-trial. That would be your remedy. Pwedeng itanong sa bar exam yung ganon. Pwede. Maganda. Also during the pre-trial, the court shall require the parties to enter into stipulations on what are the subjects of both the direct and cross-examination of the witnesses who have no personal knowledge. Okay, this is under the revised guidelines on continuous trial. Okay, stipulations on direct examination and cross-examinations of witnesses who do not have personal knowledge of the material facts constituting the crime, such as what? The forensic chemical officer in drug-related cases. They do not have personal knowledge about the facts. Ang droga, hanggang pag-examine lang naman sila ng droga. Or the chemist, or the medical legal officers, di ba anong ina-examine nila? The cadaver, in-examine lang nila. They issued a post-mortem examination report. Hindi naman nila alam yung crime. Alam nila. The investigators, or in cases of graft and corruptions, wherein one was charged based on the audit report of the auditors or accountants or the engineers or expert witnesses, they will testify only on the report. They will testify only on the authenticity, the due execution, and contents of the public documents and reports. Thus, the direct examination and cross-examination of those witnesses, I repeat, who do not have personal knowledge of the crime charge can be stipulated upon during the pre-trial. So, the court will be saving its time, precious time. Saglit na lang kasi pag-uusapan na lang nila, it can be stipulated by the parties. Okay, so very clear that the pre-trial order will serve as the guide in the criminal proceeding in court. Yun yung guide. Yun yung guide. Ito, fact number one, agreed upon, stipulated, huwag mo nang itanong. Basta napirmahan yung pre-trial order. About number 2, ay stipulated na, huwag mo nang itanong. 3, stipulated na. 4, 5, ay hindi, tanong mo. Tanong mo yan. Kasi hindi nag-stipulate. So yun na lang ang tanong mo, pipiliin mo na lang. So instead na 100 questions, baka 20 questions na lang. So there will be savings of the precious time of the trial court. Now, we now move on to trial on Rule 119. Dito ako nangagalaiti minsan kasi may Supreme Court circular dyan and now incorporated under the Rules of Criminal Procedure that the trial shall be held from Monday to Thursday. And the court shall call the cases at 8:30 in the morning and sa hapon meron din 2 o'clock in the afternoon. Yun yung schedule. Yan ang schedule ng trial. Minsan nang gagalaiti ako dyan. Dito may taga-Antipolo rito, taga-court, meron. Kabrad ko sa Prat. Bro, merong MTC dyan sa Antipolo. Tawag ng kaso, mag-alas 3 na raw. Okay. Inaabot ng alas 8 ng gabi ang hearing. Maswerte na kung alas 7 or alas 6. Daming nagre-reklamo. Pati yung security guards dyan sa Antipolo. Hindi sa Hall of Justice ito, doon sa kabila. Pati security guards nagre-reklamo na. Kasi bakit gabi ito, babantayan pa namin. Pero yan ang gusto ni Judge. Kaya sinabihan ko yung mga kasama kong piskal. Nako, kung ako ang prosecutor doon, maglilindol ang building na yan. Mag-away kami talaga ni Judge. Matira, Judge, ang matibay. Baka dudurogin kita dyan. Sumunod ka sa rules of procedure, Mr. Madam Your Honor. Babae yan. Hindi kita atrasan. Hindi ikaw ang amo namin dito. Sundin mo yung procedure ng Supreme Court. Mabuti hindi ako naging prosecutor doon. Kawawa talaga siya. Papahiyain ko siya doon. Contempt, anong contempt? Baka ikaw ang kulong ko. Ikaw hindi sumusunod. Mga kasamahan kong prosecutor, nagrereklamo na doon sa kanya eh. Mali. Later on, you'll become judges. Huwag mong sabihin ako ang judge kaya hanggang alas 6. Sabihan ko na lang yung kasama ko. Paluin mo na yan. Paluin mo. Pag judge ka, ibig sabihin, sumunod ka sa rules of procedure. Ikaw ang unang sumunod. Paano unang sumunod? Aba, 8:30 judge, tawag ka na. Simula ka na. Alas 2, tawag ka na, simula na. Huwag kang maging late kasi hindi ka ang amo rito. Ang amo dito, batas. Sa trial prosecutor, walang masabi sa akin yan. May mga taga-Antipolo to. Bro, kay Judge Santos, alas 9 yan nag-hearing. Okay lang yung alas 9. Pero alas 8, doon ako sa lobby ng court. Nag-aantay ng mga matitigas na ulo ng client, ng mga complainant at testigo. Doon ako. Kaya walang masasabi sa akin dyan dahil maaga ako. Sa 100 complainant, mabuti may 5 dyan lalapit. Hindi yan lumalapit. Ganun katigas sa mga Pilipino. Kaya pag nagtawag na, nandun na si Judge Santos, pag kinalabit sa akin, sinungit-sungitang ko talaga yan. Bakit? Ang aga-aga ko dyan. Ikaw, wala ka pa. Dapat kayo ang mauna bago si Piskal sa kasi Judge. Kami pa ang nauna. Maraming ganyan na mga tao, mga reklamador pa. Meron, hindi ko makalimutan ito. Bago lang ako ng Piskal sa Antipolo. Branch 71, RTC. Abay, sinabihan ako ng kliyente, Piskal, sabi ni Judge. Judge ng Antipolo yan, MTC Judge. Sabi ni Judge, ito daw ang gagawin. Alam mo, sa totoo lang, itong sinabi ko, ayoko nung pinagaganyanan ako. Ay di, papuntahin mo dito si Judge, siya mag-prosecutor. Or, ito yung pinakamasamang sinabi ko, papuntahin mo dito, ihulog ko siya rito. Sinabihan ko talaga. Pinuntahan niya si Judge, sinabihan, nasumbong ka, bakit Judge? Takot din si Judge. Lalaki yung Judge. Takot, bakit? Mali ka eh. Ba't ka makialam sa amin? Trabaho namin ito. At talagang ihulog kita sa hagdan para mamatay ka. Parang sinabi ni Duterte, ihulog niya yung mga auditor ng kuwa sa hagdan. Sinabi ko na rin yan sa court. Judge, walang magawa si Judge kasi ba't ka nakikialam? Pamangkin mo yan, huwag mong pagsabihan mo si Piskal itong gagawin. Dapat ang sabihin mo, punta mo si Piskal. Makipag-usap ka. Yun ang tamang payo. Hindi yung maggaling-galingan ka. Judge ka. Bakit? At magaling ka? Bago ka magsabing magaling, mag-isip ka. Kasi hindi porkit judge ka, alam mong lahat. Karaming judge dyan. Wala naman. Wala, hindi nag-aaral eh. Ang sekreto dyan sa court, mag-aral lang. Ganon din sa bar exam, you will study hard. Sa court, ganon din. You prepare your case. All right, now, so ano pang sinasabi ng rules of court natin ngayon? Yung promulgation shall be held in the mornings ng Fridays lang. Sundin mo yon. All right. On trial, there are prohibited motions. Merong prohibited motions. Bago ito. Under the revised guidelines on continuous trial. Mahilig ang mga lawyers dito nung araw eh. Yung mga taga-court, alam nyo ito, magpa-file yung lawyer. The information has already been filed in court. Anong gagawin ng lawyer? Motion for judicial determination of probable cause. Diba yung naalala nyo, Rule 112? There are 2 kinds of determination of probable cause. The first one is determination of probable cause for the purpose of filing information in court, which is an executive way of determining probable cause. Executive, right? Another one is judicial determination of probable cause. Which one? The court will determine probable cause for the issuance of a warrant of arrest. So dalawa, executive and judicial. Yung executive prosecutor ang mag-determine. Yung judicial, yung court yun. Court. Maraming lawyer dyan na i-file ng information, they will file a motion for judicial determination of probable cause. Actually, nagdi-discuss kami among prosecutor. Sabi ko, mali yung ginagawa ng mga lawyer na yan. Eh. Kasi parang inutusan mo na si judge. Huwag mong utusan si judge. Bakit? Because the judge is already mandated by the rules of court that upon the filing of the information in court, the court should examine the record of the case for purposes of determining whether or not there is probable cause for the issuance of a warrant of arrest. Huwag mong utusan. Eh hindi, ginagawa ng mga lawyer na iba yan. Pero sa tingin namin mali. Ngayon, nalaman na ng Supreme Court, ganun pala kayo. This time, that kind of motion for judicial determination of probable cause is now a prohibited pleading. Kwento lang, pero hindi nyo na makalimutan. Huwag kayong paglumabas sa court yan, baka ikukontempt ka sa ngayon. Sa bar exam, hindi ka ikukontempt. 0 lang. 0. Alright. Another prohibited motion. Motion for preliminary investigation. Motion for preliminary investigation filed beyond the 5-day reglementary period in inquest proceeding. Ano ito? Ano ito? Yung naka-attend ng discussion sa Rule 112, maybe you can ma-recall nyo, o kung hindi na-recall, sana maulit natin ito. Kasi hindi maganda noon yung connection natin. Alright, ano to? Well, during an inquest proceeding, if an information is filed by the prosecutor in court wherein no preliminary investigation was conducted but only an inquest proceeding, what is your remedy? Among others, the remedy of the accused is to file a motion for preliminary investigation. Where? File a motion for preliminary investigation with the court where the information was charged, provided that the motion for preliminary investigation was filed within a 5-day reglementary period. The 5-day reglementary period, according to the rules of court, is reckoned from that time that the accused learns of the filing of the information in court. After the lapse of the 5-day period, the accused cannot avail of a remedy of preliminary investigation anymore. Because if he will file that motion beyond the 5-day reglementary period, that is already a prohibited motion. Okay, prohibited motion. Another prohibited motion under the rules of court is motion for reinvestigation. Kanina, motion for preliminary investigation. Bakit? Kasi wala namang preliminary investigation. There was an inquest proceeding. Alright. Ito naman, motion for investigation, meaning there was an investigation conducted by the prosecutor wherein the prosecutor recommended the filing of the information in court. Okay. So, file ka. Motion for reinvestigation. But, the prosecutor already conducted a preliminary investigation. A subpoena was already sent to whom? To the respondent, now accused. And it was received by the respondent himself. But for reasons of his own, he did not file a counter affidavit. Now that an information is filed against him, he will now file a motion for reinvestigation in court. All right, you are the judge. What will you do? Denied. It should be denied. Reason? Because that kind of motion is a prohibited motion. Okay? That is a prohibited motion. Also a motion for investigation, we mentioned, there must be prior leave of court. So if there is no leave of court, the motion for investigation shall be denied. Okay, meron pang example. Your client was charged for slight physical injuries or any offense where the penalty is only 4 years and 2 months imprisonment, not 4 years, 2 months, and 1 day. Walang 1 day, only up to 4 years and 2 months. Well, if your client was charged for a crime or the imposable penalty does not exceed, is only up to 4 years and 2 months, is preliminary investigation required? No. Preliminary investigation is not required. Like for instance, less serious physical injuries. Information was filed in court. All right, the counsel for the accused filed the motion for reinvestigation with the municipal or metropolitan trial court. You are the judge. Rule on the motion. Motion for reinvestigation. Anong ruling mo? Motion denied because that is a prohibited motion. Why? Why a prohibited motion? Because preliminary investigation in that crime is not required. It is not required. So, motion denied. Kaya dapat kabisado nyo what are the criminal cases where preliminary investigation is required. Ano yon? Where the imposable penalty is at least 4 years, 2 months, and 1 day. Right? But how about the crime of libel? Ulitin ko na lang itong libel para marinig din ng iba. Baka hindi ko na maulit, baka makalimutan. The penalty for the crime of libel or written defamation is only up to 4 years and 2 months. Question, is preliminary investigation required? If you will base your answer on the provisions of the rules of court, your answer will be no, preliminary investigation is not required. Yun ang sasabihin mo. But how about under the provisions of the revised penal code? Under the revised penal code, if one is charged for libel, preliminary investigation is required. Thus, if no preliminary investigation is required, it is proper for you to file a motion for preliminary investigation or reinvestigation in court. After all, preliminary investigation is required in the crimes of libel, although the penalty is only 4 years and 2 months. Our basis would be the provisions of the revised penal code. Okay, another one. Your client was charged for attempted homicide. Question, is preliminary investigation required? Yes. Why? Because the penalty for attempted homicide is straight prison correctional of up to 6 years. So, preliminary investigation is required. So, the prosecutor conducted a preliminary investigation. The accused did not appear, did not submit his counter affidavit despite a subpoena. So, an information was filed. Okay. Sa information, naka-certify kasi ang fiscal. Diyan, this is to certify that a preliminary investigation has been conducted. Merong certification yun sa baba. Pinipirma ng prosecutor. Sinakita ni judge, meron naman preliminary investigation. Bakit naman ito nag-file? Basahin ko nga. Binasa ni judge yung resolution ng prosecutor. Nakita din naman judge. Hindi. Nakalagay dito sa resolution that a subpoena was sent to the respondent, but despite such subpoena, he did not file his counter affidavit. Neither did he appear during the preliminary investigation is scheduled on. Okay, you are the judge. Nakita mo, ano gagawin mo? Motion for preliminary investigation is denied. That is a prohibited motion. Why, Your Honor? Why a prohibited motion? Because a preliminary investigation has actually been conducted. All right. Other motions to quash. Ito marami. If a motion to quash is not among those grounds provided for under Rule 117, it should be denied. Dapat the motion to quash should be founded on the grounds enumerated under Rule 117. Pag hindi, it should be denied. Reason, it is a prohibited motion. Okay. Also, a motion for bill of particular that does not conform to the provisions of the rules of court on bill of particular is a prohibited motion. What is that? If the motion for a bill of particular, the motion itself, if the motion failed to specify, if the motion for bill of particular failed to specify the alleged defect in the information, anong gagawin mo? You are the judge. Motion for bill of particulars denied. On what ground? It is a prohibited motion. Oh, Your Honor, bakit a prohibited motion? Because your motion for a bill of particulars did not specify the alleged defect of the information. Sabi mo may depekto, ba't hindi mo naman sinasabi kung saan dyan ang depekto? Huwag mong ipahanap kay judge. Hindi trabaho ni judge ang maghanap niyan. Hindi niya trabaho. Kung trabaho ni judge, basahin, okay. Hindi siya, si judge hindi yan auditor. Na, hanapin niya lahat. Hindi, ikaw ang mag-feed. You feed to the court. What is the defect? Okay? Another one, prohibited motion. Motion to suspend arraignment. Oh, ba't ka nagpa-suspend ng arraignment? On what grounds? Well, if the grounds for a motion to suspend proceeding are not those enumerated under Rule 116, anong gagawin mo? Motion denied. Reason? Because it is a prohibited motion. Bakit? Ano bang ground mo to suspend proceeding? Kasi I will be leaving for abroad. Hindi yan ground for postponement or to suspend proceeding. If the accused is suffering from mental defect or faculty, is insane, then the arraignment can be suspended. Or there is a prejudicial question, then the arraignment shall be suspended. And another one is that the accused filed a petition for review with the Department of Justice or a petition for review with the Office of the President. And that petition for review with the DOJ or with the Office of the President is still pending. So I'm filing a motion for the suspension of the arraignment. But take note that under the rules of court, the suspension of the arraignment under that situation shall not exceed how many days? Shall not exceed 60 days. Okay, so another one, motion to suspend proceeding on the ground that there is a prejudicial question. Okay, nag-file ka ng motion for suspension of the proceeding on the ground that there is a prejudicial question. But there is no civil action filed in another tribunal or in another court. Wala ka namang pinafile. Wala. Because you can claim prejudicial question only if there is a civil action filed ahead of the criminal action or prior to the criminal action, and the issue in the civil action is determinative of the guilt of the accused or determinative whether or not to proceed with the criminal action. That is prejudicial question. Dapat mayroong civil case. So without a civil case filed ahead of the criminal action, there is no prejudicial question to speak of. Thus, the motion to suspend proceeding on the ground of what? Prejudicial question should be denied. Why? It is a prohibited motions. Alright, so ganon, prohibited motions. Prohibited motions yan, di ba? Pero mayroong mga motions na gustong-gusto ng Supreme Court. Ito, magandang motions ito. Ang tawag dito, meritorious motions. Happy ang Supreme Court dito, happy din yung court. Bakit? Sabi ni Fiscal, before arraignment, i-withdraw natin. Bakit natin i-withdraw yung information, Mr. Prosecutor? Kasi a petition for review was filed before the DOJ. Ang bilis ng Secretary of Justice. Wala pang 60 days. Ito na, meron ng resolution dismissing the criminal action and directing the city prosecutor or provincial prosecutor to withdraw the information. So what will the trial prosecutor do? If you are the trial prosecutor, anong gagawin mo? Ay natural. Anong natural? Natural, sumunod ka. Kanino ka sumunod? Sa Secretary of Justice. So you will file a motion to withdraw information. That is a meritorious motion na allowed under the rules of court. Pero naka-experience na kami ng motion to withdraw information. Kwento ito, but you will be informed well on this. Alright, ito yon. I was then the officer in charge of the city prosecutor of Antipolo. We filed an information before the family court, RTC, Branch 72, Judge Santos, for violation of Republic Act 92, 62, Violence Against Women and Their Children's Act. Ang akusado dito, hindi ordinaryo, super yaman. Talaga mga big time. Big time. Ang mga anak niya, nag-aaral, yung isa, University of the Philippines, Diliman. Yung isa, De La Salle University. Yung isa naman, sa University of Asia and the Pacific. Pangmayaman ng mga eskwelahan lang. Yung UP, okay lang. Yung dalawa, iba yan. Hindi, super yaman naman talaga. Nako, hindi na nagbibigay ng support. Ang misis niya, dentista, nagkakaroon ng gulo sila, hindi na nagbibigay. So, violence against women. Alright. During the arraignment, he pleaded not guilty. Okay. Pleaded not guilty. Right? But at the time of the arraignment, he already filed a petition for review with the Department of Justice. Meron na. Pero the counsel allowed himself to be arraigned. Dapat anong gagawin mo? If you are the counsel, kwento ito pero subject natin. If you are the counsel, do not allow your client to be arraigned first. You move for the suspension of the arraignment on the ground that there is what? A pending what? Pending petition for review with the DOJ. But of course, the suspension is limited only for a period of 60 days. Hindi, nagpa-arraign. Di-arraign na. Minsan, Pilipinas talaga ito, minsan hindi maalis na siguro baka may connection. Our resolution was reversed by the Department of Justice, not by Secretary de Lima, hindi si Secretary de Lima, but an undersecretary. Of course, the undersecretary is authorized. He was authorized by Secretary de Lima. Siguro sa trabaho ng Secretary de Lima, he was authorized. Ito na nakalagay. There is a reverse the resolution. Here is now the directive for us to withdraw the information. Inutusan na kami to withdraw. If you are, okay, tanong, if you are the prosecutor under that circumstance, are you going to withdraw the information? Palagay mo, you will withdraw. Tandaan nyo to hindi naman, malay mo, lalabas din sa bar exam ito, are you going to file a motion to withdraw? Motion to withdraw information, take note, is a meritorious motion under the revised guidelines on continuous trial. Are you going to file? Magandang pang-recitation. Wala tayong recitation dito. Kami, we did not. No. Mabuti na lang yung mga prosecutors doon, yung trial prosecutor, mga astig yun. Yung taga-Antipolo Hall of Justice, si Fiscal Banggi ang prosecutor doon sa Branch 72. Hindi mo kaya yan. Lalabanan ka ng mga yan. And another one, the prosecutor who handled the case is Prosecutor Roy. Hindi mo rin kaya yan. Di prinsipyo yan. Hindi mo kayang gulat-gulatin yan. Roy Insyong. Pinuntahan ng counsel ng accused. Pinuntahan si Roy Insyong. Fiscal. I-withdraw na yung information doon. Ito may direktiba. Sabi ni no, ang trial prosecutor si Fiscal Banggi. Hindi rin papayag. Would you believe? We were threatened by the undersecretary, by the council. Not undersecretary. We were threatened by the council that an administrative cases shall be filed against us for insubordination. Naku, wag mong hamunin yung ganyan yung Fiscal Insyong. Pag tama yan, hindi yan atras. Sabi, no, you filed administrative cases against me. Against us. Would you believe? Gusto mo magharap pa tayo kay Dilima o doon tayo kay Dilima? Walang magawa yung lawyer na yan. Nagtapang-tapangan, wala naman palang silbi. Wala pala. No, we did not heed the order of the DOJ Undersecretary. Ba't kaya? Okay. Ito yung criminal procedure para malaman nyo. Bakit? Ba't hindi kami sumunod? Anong sabi ko kanina? He was already arraigned. Tandaan nyo. He was already arraigned. Now, if we will file a motion to withdraw information and subsequently after a reinvestigation, again, we will file probable cause against the accused. And once we file another information for that purpose, the accused will simply what? Invoke. Anong i-invoke? He will invoke his right, constitutional right against double jeopardy. Kaya hindi talaga kami pumayag. Kaya nga sabi nga kahit harap pa si Dilima, totoo lang, sikat yun undersecretary, sa totoo lang. Mga politiko kasi, sa totoo, pag umuwi ako sa bahay, nakita ko sa TV yung mukha na yun, nag-PPI ako, minumura ko yung TV. Ikaw yusik ka, suntukin kita. Huwag mong ipahamak kami. Kami ang mapahamak dyan, ikaw. Yusik ka lang. Ba't minamaliit ko yung yusik? Yusik ka lang. You can be removed anytime as yusik. Kami, hindi, iba naman yung trabaho namin, permanent. Mabuti na lang pinaglaban namin yung tama. Sa kapasalamat din kami. Kasi meron ding private prosecutor yon. Maano din, palaban din eh. Tuwang-tuwa nga sa amin yung tuwang-tuwa yung private prosecutor saka yung private offended party. Kasi nakita nila yung grabe kami lumaban, na matinding labanan ito. Kahit undersecretary yan, hindi namin inaatrasan. Why? Kasi nasa tama kami. Mabuti hindi talaga nagka-enkwentruhan dahil hindi namin talaga atrasan yung music na yun. Huwag siyang magaling-galingan kung hindi siya mag-aral ng maigi. Alright, so motion to withdraw information. Gustong-gusto ng court. Another one. Suppose your client was charged for prostrated murder. Okay. The prosecution filed a motion to downgrade the charge from prostrated murder to only frustrated homicide. Okay. Is that a meritorious motion? The answer is yes, granted yan. Granted, gusto ng court yan. Although wala namang mawawala sa court. Yung court may trabaho pa din. Another one, motion to exclude one of the accused originally charged. Alisin namin to. After a reinvestigation, it was disclosed na he did not conspire with this co-accused. Motion to exclude. Pero actually, nasa judge pa naman yan eh. Nasa judge pa ang discretion whether to grant or to deny the motion to exclude the accused. Nasa kanya yan, sa kanya. But anyway, that is a meritorious motion allowed by the court. That is allowed by the court. How about motion to quash a warrant of arrest? That is a meritorious motion allowed. To suspend proceeding on the ground of unsound mental condition of the accused. Okay yan. Allowed. Motion to suspend proceeding, prejudicial question, yes. Motion to quash information on the ground that the facts charged do not constitute an offense. Yes, meritorious motion. Anong gagawin ng prosecutor? I-amin lang naman nila yung information. I-amin. The charge do not constitute an offense. The prosecutor will amend the information. Okay, another one. Motion to the quash on the ground of lack of jurisdiction over the subject matter. Talagang meritorious motion yan. Lack of jurisdiction. Motion to quash on the ground of extinction of criminal action. Yes. Motion to quash on the ground of extinction of criminal liability. Meritorious. Another one. Motion to quash on what ground? That it would violate the right of the accused against double jeopardy. Yes. Allowed. Meritorious motion. Another one is motion to discharge the accused as a state witness. Allowed ba? Yes. A meritorious motion. Another one. Ito, maraming sakit ito. Motion to quash search warrant. Also motion to suppress evidence. That is allowed. We will discuss thoroughly later on motion to quash search warrant under Rule 126. Naku, ang daming Actually, ang daming violation dito sa yung search warrant, application ng search warrant. Ang daming violation ng mga law enforcers dito. Kaso, hindi rin na-actionan ng mga defense counsel. Hindi na-actionan. Kaya ayos lang, dapat na-actionan. Another one, this one. Baka marami sa inyo dito, ngayon nyo lang narinig. Siguro, time na ba? Alright. Ngayon lang. Alright. Importante to. This is included in the syllabus for the bar examination. Okay. Motion to dismiss. Motion to dismiss. Motion to dismiss on the ground that the criminal case filed against your client is a slap. Sampal, strategic lawsuit against public participation. How it came about that there is a criminal case on slap? Okay, your client is is a forest ranger of the DENR and other officials of the Department of Energy, Natural Resources, DENR. Nagtrabaho lang naman talaga sila. Hindi sila corrupt, hindi nababayaran itong mga taga-DENR na to. Hindi. Talagang they recommended for the filing of cases against violators of the environmental laws. Maraming environmental laws ito as enumerated. Napakarami. Okay. As a consequence of their investigation, the persons affected by their investigation filed a criminal complaint against them. Whatever criminal complaint. Minsan, sasabihan na nanghihingi ng lagayan. So, sasampan sila ng kung ano-anong kaso, anti-graft, bribery, kasuhan. So, also administrative cases, para lusot lahat. Alright, you're the counsel for the officials of the DENR. Ikaw yung counsel. Okay, tanong, what would be your remedy? Okay, what would be your remedy? Your remedy is that you will file a motion to dismiss the criminal action on the ground that the criminal case is a slap. Pag ako nag-lecture sa review center nito noon, binibiro ko lang, sampalin nyo yan para ma-dismiss. Ano yun? Strategic lawsuit against public participation. That would be your remedy. Once you can prove it in your motion, and your motion is accompanied by affidavits, then the criminal action will be dismissed by the court. On what ground? Slap, strategic lawsuit against public participation. Now, how about the administrative cases filed against your client? Can it be dismissed on the ground of slap? Yes. The administrative case against your client can also be dismissed on that ground. Even civil action for damages against your client can be dismissed on the ground of what? Slap, strategic lawsuit against public participation. Okay, so lawsuit. Tandaan nyo yan, siningit ko lang yan, pero sinasadya kong isingit para sigurado na masasabi natin lahat. Baka mamaya, nakatsamba lumabas sa bar exam. Anong sasabihin nyo? Wala yan. Kabisado ko na yan. Bakit? Kabisado ko. Narinig ko kay Luna. Hindi lang. Narinig ko kay Luna pero binabasa-basa ko pa ulit-ulit yan. Kaya hindi na ako magkakamali. Kaya ang grade ko sa Remedial 95 lang. Minalas pa. Minalas. Civil law, 95 din ako. Patay ka. Number 1 ka sa bar. Commercial law, mababa 90 lang. Tingnan mo. Taxation, 98. Bakit? Kasi si Dr. Lin yung nag-lecture sa amin. Nag-lecture pala kanina. Thank you so much, ma'am. Actually, kasama naman ako sa grupo nila, yung Powerhouse Bar Review Center. Sinasama naman ako nila. Yan, saan ba? Marami nung araw, ang dami. Ang daming lugar diyan sa Isabella, Kawayan. Saan pa? Diyan, Kinaduming. Kinaduming. Anong lugar tong Kinaduming? Sa Santiago, Isabella. Nasubukan ko rin sa La Union. La Union. Dati meron pang Legazpi City. Natigil lang yung Legazpi kasi mayroong review center doon ata na iba. Yung sa UST. Meron pang Osamis City. Kasama ko yan si ma'am at I'm so grateful with her. Pinagbigyan pa kayo. Saka grateful ako sa kanya. Kasi sa kanya ako magsimula mag-lecture outside Metro Manila. The first time I lectured sa Baribio, kinadintan, dinfistin sa Academicos. And later on, of course, where I belong, the Polytechnic University of the Philippines College of Law. Saka sa Villases, pinapalecture naman ako ni Attorney Kit dyan. Although, iwan ko ba't sinasama niya ako. Alam ko may mga membro din. Sinasama pa niya ako. Yung grupo nila, Remedial. Lahat nata na magagaling ng Remedial, nasa kanya na. Sinisingit-singit pa rin ako niya. Okay lang. Baga kung Remedial lang, Villasos Law Center, ando na lahat. Dinmoya, Villases, Justice Singh Ataok, mayroon pang isang, ando na lahat sa kanya. Sinisingit pa ako, pero I'm so grateful, I'm so honored naman kasi nasama-sama pa rin niya ako kahit na punong-puno na sila. Si Attorney Kid sa Villases Law Center. Si Ma'am Lim kasama din doon, kasama din sa taxation. Hindi ko in-advertise, kinikwento ko lang how it happened na nagkakilala kami. Alright, may membro din dito. Nandito isang mga grupo ng Powerhouse Law Center. Mga taga doon sa Malamig. Taga Baguio yan sila. Nandyan. Kasama din dito. Okay, maraming salamat. Next time, ituloy natin. Iwan ko kung matapos itong criminal procedure. Baka hindi pa. Baka hindi pa. Baka 2 Sabado. Bakit kaya? Kasi masyadong detalyado yung pag-explain. 2 hours nga lang, dinidetalye pa. Unless magdidemand kayo, huwag nang idetalye. Okay lang. Hindi, dinidetalye ko to kasi wala namang time frame. Walang time frame. Kaya hayaan ko lang. Sa review center hindi, may time frame yan. Kaya mabilisan. Okay. Okay, maraming salamat sa nag-attend dito. Anyway, naka-ano naman yata ito. Naka-record, pwede namang paulit-ulitin. Pero ang hindi naman ata mas-share ito at huwag talagang i-share din. Domain, di ba? Kasi para lang ito sa atin, yung sumasali dito. Saka kung may mga kaibigan kayong law students, law graduates, isama dito. Huwag naman yung domain, di ba? May nag-request criminology. Sa akin, okay lang naman yun, kahit criminology. Pero no, this group is intended for law students and law graduates. Huwag na nating ihalo. Saka, lalo na remedial. Kahit criminology ka pa, hindi ka naman magkaka-interest ng husto. Civil procedure na, magka-interest ka ba? Hindi. Unlike law students and law graduates, lahat kayo magka-interest. Bakit? Ayaw nyo magka-interest? Di huwag, hindi kayo papasa sa bar. Whether you like it or not. Ganun, magka-interest kayo. Alright, thank you Next time na lang, next time. Pagbutihan lang natin ito ng gusto. Para you will pass the bar examination.